Okay, so hello, it's nice to be here and thanks very much for letting me speak. I should say I've not written my paper, so that's my first disclaimer. This is going to be a selection of ideas and I very much welcome sort of comments, criticisms and thoughts that you have on it. My background is that I have principally been researching public and private relationships in a policing context. So largely in the area of money laundering. And in the course of that work, it became really apparent that there was quite a propensity to use sort of high level crime narratives to justify the collection of financial data. And that sort of made me very interested in particular in sort of privacy and data protection. And the relationships between one another in this kind of context where you're moving from a private organisation to a public organisation, or indeed vice versa, as they try to tackle these issues. So that's kind of how I guess I've arrived in looking at issues of data. But in this case, as fortune would have it, I was going through the proposed bills section of the Parliament's website, because that's one of the most thrilling things as a lawyer you can do. And I came across the Judicial Review and Courts Bill. It was introduced in July of 2021. And when I saw that it had included online automatic convictions, I had a really visceral response. I immediately thought, this must be bad. And that was categorical. The reasons I had to then try and backfill. Okay, so that was my initial thought, was this is bad. That was my premise. I had to then try and think, why is it bad? Okay, what is it that makes me think that it's bad or reach that conclusion? And for most of you who are lawyers in the room, it won't be a surprise as to the reasons why I think that there is an issue here. It presents a threat to the principle of open justice. It has the potential to prohibit access to justice. And ultimately, the narratives that are given are ones of efficiency in public administration. That's the foundation of why it is being introduced, that it will save court time, that it will potentially improve the backlog of court cases. And so the arguments that are then put onto that are that justice delayed is justice denied. So actually automatic online convictions are a benefit to you. So, how do I change slides on here?
Yes. Okay, here, start the video. And to change the slides, you can use this.
Is that
yes. Yes.
Okay, so one other sort of point to note is that this was introduced, or the bill was introduced at a time at which the principles of open justice were already being eroded, and they were being eroded because of COVID-19. So COVID-19 is responsible for a lot of things, and one of those things is that gradually they have been able to introduce a lot of restrictions on the courts, and that, if you like, has been justified. But as we transition out of the pandemic, there should be a return to open justice. But in the meantime, they've introduced this bill to allow these automatic online convictions. So that's all well and good. It means we have to look at actually what are they saying in the course of this bill. So you'll see here, section 3, pretty straightforward, electronic notification that explains that a person intends to plead guilty can be lodged. And when they do that, they're agreeing to be convicted of the offence and that they will be penalised for that offence. So that's fairly neat. It applies to a person or an entity, so it's not just individuals. And you have to obviously accept, so it's an opportunity. It's not compulsory for you to be automatically convicted. You have an option here, you can say no. But largely, as you can imagine, narratives have arisen about the sort of pressures that come from the perception of convenience, that it might be more convenient to accept an automatic conviction than to, for example, have to go to court to a hearing where you're going to plead guilty anyway. But that perhaps underestimates the sort of power of having to engage in the physical act of going to a courtroom and what that means about your thought processes in the journey, and also the potential of you to actually interact with other people who might be able to give you good advice about whether or not pleading guilty is appropriate for you. So here there are questions about how we make sure that there are mechanisms by which individuals who are receiving this opportunity can be given advice, and I'll come back to that a little later. So you'll see that it also allows, for example, a legal representative to accept on somebody else's behalf. So reassuringly, there are some qualifying conditions. So it's not a free-for-all in terms of what offences might fall within this. The Lord Chancellor has to make some regulations, and he will set out what offences for which this opportunity will be presented. And they can only be offered to people who are over the age of 18. And they have to be in accordance with the rules of criminal procedure. So therein lies the ambiguity. What are the offences that the Lord Chancellor is likely to include? Well, there are further qualifications in that they will be made by statutory instrument. They have to be approved by both houses of Parliament. So that's really important because it makes sure there is a mechanism of accountability in those choices. And it can only include summary offences that are not associated with imprisonment. So that seems to make it appear quite a friendly option. It's very limited in scope, that's great. But summary offences can actually have big consequences. There's a sort of narrative associated with this where they sort of downplay the offences that it's seeking to target. So for example, in the debates, government put forward that it would only apply to, for example, using the wrong fishing equipment was one of the illustrations that they used. Now clearly, okay, I understand that as an example, but they also then said, well, it will only apply to road traffic offences. So again, there's a certain degree or a certain indication that when they say that, they're almost saying road traffic offences don't count as crime. You know, they're also saying, oh, it's only road traffic offences, so you don't need to worry about that. Everyone's had some form of road traffic incident. That's not true. I did once get stopped for driving without an MOT. It was terrible. It was really traumatic. And it was completely ignorance. They didn't give me any charge. Anyway, so I thought, so the associated penalties that this can have. So if you accept the automatic online conviction, you can only be penalised by a fine or an endorsement on your driving licence. So again, that's fine. That's actually the same as you would get if you were to go through the alternative processes. So it isn't that jarring that those options are there. But we shouldn't underestimate that when you are presented with an option, your ability to appreciate the consequences of that option are impacted by how it's communicated to you. So there is a difference between, for example, reading a letter, taking the time to read the letter, of course not everyone does, and thinking about what that actually means, as opposed to getting an online notification where you can have an instantaneous response. There's a certain benefit to the delay in the reflection that might come with a letter notification. Now, I should say I'm making gross generalisations here as I go through this, okay, so that's one of the gross generalisations. And I thought it might be helpful to give you some context of specific summary offences that technically would meet the proposed definition that's given at the moment in the Judicial Review Act. So here, the typing's a little small, but Section 3 of the Road Traffic Act 1988 would include careless and inconsiderate driving, a fine of up to £5,000, discretionary disqualification, and obligatory endorsement. The Section 12 is motor racing on public ways, particularly problematic around my area. Do you know why? There's a lot of racing. Up to £2,500, obligatory disqualification and obligatory endorsement. Now, when I read this, the first thing that jumped out to me was discretionary disqualification. And the reason that that jumped out to me was because that indicates that there is going to be some form of choice in sentencing, and that means who's making that choice. So when we're talking about automatic online conviction, are we saying that the whole process is going to involve aspects of effectively algorithms making decisions? So who's doing the case marking? What are the influencing factors that they're taking into account? How are they processed? So a lot of that is not addressed, obviously, in the proposed legislation. It's open to debate. The prosecution service down south use a case management platform called the Common Platform, but there isn't actually any information. I haven't seen any research that's been done on that and how that operates. And case management systems have been in existence for years, as we will all know, both in private sector and public sector, so they're not new. But I think given that we are now becoming more critical about the influences of those types of technologies, we should also consider it in the public sector context. So we should think about those influencing factors. Okay, so I'm particularly interested in the role of discretion here. So if we follow this through from one side to the other, we have an offence being reported, we have the electronic notification of offer, we have an acceptance of that offer, and we have the penalty. Now, at the top of the slide, I've tried to indicate that you really have two choices here from the discretion. You might have a human making the choice, or you might have an algorithm involved in the process. And as I've said, it's ambiguous. There are really two trigger points. One is who gets the opportunity. So who's actually going to be given this opportunity for automatic online conviction? Presumably, there will be a case marking process by the prosecutor where he elects who is going to be given the opportunity. But at the moment, the legislation doesn't set any parameters on how that would operate. So the only feature that we know about is the regulations that will restrict the scope of the offences. So that will be the principal factor. If you're on that list, you might get the opportunity. But there will then presumably be other criteria that will be taken into account in giving the letter. Then you will receive the letter. It's not insignificant that the letter is going to be served electronically, because it presumes that we all have access to technology. It presumes that we're all confident in the use of that technology. Now, there is a well-documented link between poverty and criminality. So the likelihood is that those involved in this process are going to be disproportionately represented, and so arguably require greater protection in terms of how they're going to receive notification and whether or not it's appropriate. So will that be a factor that's put into the prosecution decision making? And how would they know, how would you be able to assess without doing some form of pre-assessment criteria that a person falls into the category of potentially suffering from various inequalities? So that is an issue. If they're then to overcome that issue and be given access, so if we were to say, okay, what we'll do is we will send them a letter that says they have the opportunity for automatic online conviction. The legislation only says that they'll get electronic notification. It doesn't say that they'll get a letter about it. So if they will get a letter saying that they can have this opportunity, so then they go to the computer, find a computer in the library to take up this opportunity, then that means, again, they've got to work out how to use the website, which presumably will be quite intuitive, that's great. But do they really understand the legal impact of the choice that they're making? So, for example, while some aspects of fixed penalty notices are, for example, not reportable if an employer makes a request, you don't need to declare it on employment forms. But if you have a disqualification for driving, then obviously you can't take up any jobs in driving. So you might think it's a convenient opportunity now, but then later you might regret making that choice where you potentially could have had some advice on whether or not it was appropriate to have that penalty attached. So there are real kind of issues there. After we know that a person has been chosen to be given the opportunity, then the next point where you would see potential issues of discretion would be between the acceptance of offer and the penalty. So again, how are they making the sentencing choices and what is the process that is followed there to make those choices? So we have a great deal of unknowns here. And as far as I can see, very little policy to support how they're going to implement the system. So that is very problematic. But there are safeguards. The safeguards are, what would you say, presumed to address the issues, presumed. So the limiting to summary offences that are non-imprisonable is meant to make this palatable, something that we are willing to engage with because it will reap benefits in terms of efficiency for the courts. It will improve the backlog for certain issues. But I'm not sure if that promise will be delivered, because they also have the possibility to set aside a conviction or a penalty. So you would have to have this mechanism. If you're going to have an automatic online conviction, you effectively have to work in some kind of an appeal process. So the usual approach to criminal appeals is that you would have to have fresh evidence that suggests that there's been some form of issue with the original trial. And evidently here, that opportunity wouldn't apply. So you need a statutory mechanism to facilitate an appeal. So this is that statutory mechanism. And it says that either the person who's convicted, the prosecutor who initiated the proceedings, or the magistrate's court itself can make an application to set aside the conviction or to substitute the penalty where it is unjust. And there is no definition given to what is unjust or what the parameters of that injustice would be. So, for example, thinking about the process of completing the form, if you have someone who isn't confident with technology, doesn't necessarily understand the declaration that they're making, they tick the box to say they're guilty, and they don't know what a plea of mitigation is. So say there's a part in the form that says plea of mitigation, they don't complete it. But at a later date, they then have an epiphany, a conversation with someone who says, oh, you know, you shouldn't have pled guilty, or you shouldn't have been given that sentence because you had a reason. So, for example, being chased by someone on the road would be an illustration. It's not a defence, you were still speeding, but there is a reason why you were participating. So if you didn't know that, you might want to then go back. But the key thing there is that it has to come to your attention. You have to know that there has been some form of injustice in order to action it. And how do you find out about that? So if there isn't a notification procedure for the individual person that they have this opportunity to have the decision set aside, then it is effectively not worth the paper it's printed on. Or is that the wrong metaphor for this example? So here you would want to make sure that there was a statutory requirement for the ability to have the decision set aside in the notification that they originally received. So from the outset, if they, for example, accidentally tick the box, that they know they can effectively challenge that at a later stage. So those are really the kind of principal safeguards that are notionally there. And in looking at this, I became a bit, what would you say, I was drowning in the literature on nudges, right? So largely the narratives are in healthcare about making positive change, but there is some literature on what have been expressed as evil nudges or digital nudges, and how things can be designed in a way to influence behaviour. So really my question here is about how appropriate is it for a prosecution service to be engaging in a situation where they're nudging individuals towards a particular outcome when there has been effectively no assessment of the potential impact, particularly on certain demographics who may be affected. Now, you know how when you do research and you have these great epiphanies and you think, oh, I'm really onto something, and then you read something else and you see someone else has already done it? So that happened last night. It turns out in the parliamentary debates, one of the Labour MPs actually right at the start of the debates had said that in his view, there should be an independent report required prior to this section being brought into force. And he said that the function of that independent report should be to effectively assess what the potential impacts are. He was unsuccessful in making that plea, but I think it is sort of a really important one to acknowledge. Sorry, quickly. So I think there are kind of three primary concerns or considerations around which these coalesced. So one is the power dynamic between the state and the individual. The state have all the power here, the individual has very little, but it is presented as though they have control. The fact that they have this option of automatic online conviction, and it is an illusion. Okay, so I'm concerned about that. The issue of privilege is quite dominant in this narrative because of the access that you have to digital technologies, your confidence with it, your digital literacy, all of those things will impact on how you receive such a notification and the choice that you make in engaging with it. And when it comes to making a plea in mitigation, you're much better placed to articulate why, for example, your sentence should be different, or your penalty point should be lower, or why you shouldn't be disqualified from driving, and so on. So you're much better positioned to do that. And lastly, poverty, which I've already sort of briefly covered. And there is an interrelationship between those things. Now, you could make the argument that these things all exist in the current written system. They all exist in the current hearing system. So it made me laugh, Angela's comment about disruption, you know, and the narratives of disruption, that this is not new, that a lot of these problems are inherent in the system. But my point is, if we are introducing a new mechanism, should we not be attempting to make things better Should we not be trying to improve on some of the inequalities that we currently have in our system? Is that not the entire point of, for example, innovation in technology? So with that, I will leave